Krupp's opinion from March or August, I'm sorry, of 2017, in which he said there's no doubt that there's a duty to defend. It's in the terms and conditions. There's never been really a debate about that. But the defendant, plaintiff in cross-claim here, was required to prove breach, causation, and damages. And they did none of that in this case. And the second is, did Shaw's actually do that? And the answer to that question is no, they didn't, for a number of reasons, not the least of which is that issue was actually tried to a jury in February of 2016. The plaintiff...
So walk me through that. How would you establish your damages for a failure to defend in the middle of the trial in which you're incurring those damages?
Yes, Your Honor, there's actually... there's two ways. The first is that once the indemnity, I always get those confused, but once the indemnity it says that the claim for, in this case, the breach of contract is going to be decided by the jury, which Mr. Shaughnessy said live on the record. It's in the record appendix at page, I think, 181 to 185. Then he either got to produce evidence, which would include showing what his invoices were, what costs and fees were incurred, and that those costs and fees...
But he's incurring those costs during the trial. He's paying a lawyer to defend during the trial. How is he going to establish his damages in the middle of the trial where he's still suffering the damages?
That actually gets to the second option, and the second option is you could ask to bifurcate that issue and have that decided later. For example, if you look at how this is almost always done in my practice and in the case law, for example, even Saibi, which is quoted here, what happens is the issue of indemnity and defense is then decided later after the first case is tried, if the case is bifurcated, or in Saibi, a different case is brought, which makes it actually
practically cleaner. Isn't that what happened? It seems like the parties agreed at the first trial that the only thing that would be submitted to the jury are the underlying negligence claims. So, I read Judge Krupp's later decision to be saying essentially the cross claims were deferred.
Actually, Your Honor, that is not what the parties agreed to at all. And if you look at the transcript, and let's see if I actually have a copy. It's Record Appendix 9, huge Record Appendix here, page 180 and on. The question Judge Krupp put to Mr. Shaughnessy, what claims is Shaw's pursuing against Stanley? In other words, we were having a charge conference. And Mr. Shaughnessy said, a breach of contract claim. And if he's going to pursue that, then he has to introduce the evidence to show breach, causation, and harm. There's no doubt that he didn't do any of those things. Certainly not damages. Now, going back, Your Honor, to your question, and that is, what do you do? The second issue, like in Saibi, like in many of the other cases, like in the Upton case that the plaintiff states in his brief, you look at, after the case is over, the plaintiff now has to prove, seeking indemnity or defense costs, what defense costs were related to the...
after.
What's called after. You could do it that way. What costs were related to the defense of the plaintiff's claim against, in this case, Shaw's. But that's not what happened here. What happened here is they put all of their legal bills on for everything that happened in the entire case, and most of it was pursuing claims.
I mean, your quarrel is with the ruling of law that the indemnity clause gave rise to a duty to defend all the claims. I don't really see how you were prejudiced at all by the conduct of the way that the judge conducted the proceedings, right? So you're quarreling with the question of law, which you're entitled to do, and that's before us on appeal. But how are you prejudiced by the way that the trials were conducted?
Well, I'm not saying I was prejudiced by the way...
Don't you have to show prejudice in order for us to reverse on that basis?
No, I don't think so, Your Honor. I mean, to that issue, which was the second issue I brought, once the case was, the plaintiff rested, then Mr. Shaughnessy rested on behalf of Shaw's, I got up and moved for a directed verdict because there had not been any evidence on breach of contract on any of these The
judge was plainly under the impression that those claims had been deferred. And this goes to the conduct of proceedings where, our deference to the judge is at its highest. So, you have to show prejudice in order for us to reverse on this basis.
Fair enough, Your Honor. So let me just close the loop on that.
Yeah.
When Justice Krupp said in his opinion, which was 18 months after the trial, after my motion for directed verdict, and he never ruled on it, he did not have in front of him the benefit of the transcript that we now do have. Unfortunately, it took us an awful long time to get the transcript, and I don't even think I had the transcript until earlier this year. And so what he did not have was the colloquy in which Mr. Shaughnessy is on record saying things like that there's going to be a judgment, we have a verdict, if it arose out of the work, and we're entitled to indemnity and defense. And then the issue became, does he need a separate question on whether it arose out of the work, or is substantial contributing factor enough? And Mr. Shaughnessy made the express decision that the way it was phrased in the special question slip that was sent to the jury of substantial contributing factor essentially meant arose out of the work. So there was no doubt that he was trying this claim on breach of contract. And so now the question goes to follow up further, Justice Chin, on your question. What was happening here is, if you're in Mr. Shaughnessy's position, I don't blame him for this a bit. He does not want, I wouldn't think, to put on a lot of bills where it was pretty evident during the course of this trial that Shaw's was negligent and Stanley probably was going to skate. And that's exactly what happened. And the reason, that's what the jury found. And the reason was, they admitted, the manager admitted that they didn't do the daily safety check, that they didn't train their people how to do the daily safety check, that they didn't know how to do it. And it's important because of how these things work. They've got the motion detector, and the motion detector will change over time, and sometimes it will contract. It's something called creep. And so you have to make sure there's no creep to make sure it's safety and within the ANSI specifications. But there's no doubt that Shaw's didn't do it and didn't train anybody to do it. And Shaw's only defense to that was, well, it's Stanley's fault. And that's why Stanley could not provide an independent defense for another law firm for Shaw's before the case went to verdict. Because the only defense that Shaw's had was it's Stanley's fault. Under the ethical rules, I think it's 1.7a and 1.8f, if I remember correctly, they could not hire somebody, pay that lawyer, and then have that lawyer say, our defense is it's Stanley's fault, while Stanley is paying for it. So there's no way that they could have done what Shaw's repeated.
I don't get that. It's only prohibited if the representation be materially limited by the lawyer's own interest in accommodating the person paying the lawyer's fee. Unless you were going to put pressure on the lawyer you were hiring for them, why would that be invoked?
Well, the reason, Your Honor, is this. Let's put ourselves in the position of the defense lawyer who's now being paid by Stanley to pursue a claim against Stanley, which I think is a violation of the rules. But if that's the case, and let's say the case goes to verdict, as this one did, and let's say Stanley gets off and Shaw's gets hit, both for negligence and causation, and let's say they award $500,000 in damages. The next lawsuit then is going to be Shaw's against a lawyer that Stanley hired on the grounds that his loyalty was divided and he didn't really press the claim against Stanley, which would have given him the right of indemnity, common law indemnity at least, or maybe even contractual indemnity under the terms. And so that's why, Your Honor, Saibi and all these other cases, what you have is you get to defense, if any, after it's all done, typically. But somebody has to make that decision instead of trying to have your cake and eat it too, which is what happened here in the trial. Mr. Shaughnessy wanted to have his cake, they say, we're going to pursue this, but eat it too by saying, yeah, but I'm not going to put in the elements of the damages. But he has to, which is why I filed a motion for directed verdict, and why I don't think Judge Krupp had discretion to deny that motion, because there's no doubt that the critical elements of the claim at trial had not been, not only had not been proved, but they had not even been entered.
Maybe it'd be best before your time runs out to explain why the in for one, in for all rule shouldn't apply in this context.
For a number of different reasons, Your Honor. First of all, it's pretty plain from Wilkerson, for example, and others, that Massachusetts does not apply the in for one, in for all in the commercial context cases and purchase orders like this. There are several cases that we cite. Secondly, the Wilkinson case in particular from the SJC, Justice Cordy points out in that case that what was going on there was an indemnity claim. Citation Insurance Company was the defendant in that case. And they said, well, we have been deprived of our benefit of the bargain because we had to go and pursue this case, so we should be entitled to those fees too. And Justice Corey said that's a violation of the American rule, and we stand by the American rule. So to the extent that's implicated in this, which it really is, because of the $170,000 or so that Mr. Shaughnessy's firm asked for, probably $155,000 or $160,000 were all their attempts to against Stanley, not their defense protecting against the plaintiff's allegations. And as the Visigard case, Mount Auburn Insurance Company versus Visigard says that an obligation to defend does not include an obligation to prosecute, to be paid for an obligation to prosecute. Those are two different things, even in the insurance context cases. So, Your Honor, the in for one, in for all, which for separate reasons is important in the insurance coverage cases, because you can't parse whether this is or that covered, or sometimes they're overlapping. That does not apply in this case where it's a purchase order in a contract that is negotiated between two commercial entities.
I had it about a quarter was spent on establishing your duty to defend and about 3/4 spent on defending against Gorelick's claims. Do I have that wrong?
Yeah, I think you get it backwards, Your Honor, absolutely. I think it was and that's another issue, that the plaintiffs, Shaw's, never broke it out. And when I asked Justice Henry at trial in the subsequent trial that ultimately was aborted, I was going to bring that out, and Justice Henry wouldn't let me make that argument, that there has to be a tie between whatever the legal fees are and what is covered under the terms and conditions of the purchase order.
So let's assume that we agree with you that the duty to defend was limited to claims that Stanley breached the warranty. What is the disposition? Do we remand?
I think, Your Honor, you have some discretion there, honestly.
I'm sorry?
I think you're right. I firmly believe that that because there was never, the issue was actually tried in the first case, as you will see in the transcript when you read it, that Stanley is entitled to a directed verdict. However, if you're talking just, leaving that issue aside, if you're saying just on this, then yes, Stanley, the parties are entitled, both of us asked for a jury trial, which we didn't really get. And so we're entitled to remand and have that issue so that at least the plaintiff, they have an opportunity to tie one issue, this legal fee, to that.
What would be decided at a jury trial if we remand?
Breach, whether there's a breach, whether there's harm. It's just exactly what Justice Krupp said.
I mean, wouldn't it just be limited to the amount of fees that was spent, that Shaw has spent defending the claims against Stanley?
Not just that, Your Honor, because if that's the case, I was never complaining about the hourly rate that Boyle Shaughnessy charged. It's an excellent firm. Their lawyers are wonderful lawyers. I never said that they, over-lawyered the case. I don't think that that's the case at all. But what they did do was they have to, as Justice Krupp said in his 2017 opinion, may I come?
You can answer the question, yes.
Okay, thank you. What they did do is, what they must do is identify which legal fees are reasonably related to defense of the plaintiff's claims, and whether there's actually a breach of duty at all. Because I have an argument that there's not a breach of duty at all.
Okay.
Based on
I think that answers the question unless there's... Thank you very much. Very good argument. We will hear next from Attorney Hodgkins.
Thank you, Your Honor.
Good morning. May it please the Court, Tom Hodgkins for the appellees. To start off, I want to focus the Court on what this is a dispute about. It's a dispute about a duty to defend. It's not about an indemnity claim. And the defense, as the Court knows, is a separate and independent obligation from the duty to indemnify. It cannot be determined by the facts at trial, and the obligation to defend is not impacted by anything that happens at trial.
Can you tell me a little bit about your theory of the scope of this duty to defend? 15 years after you buy these doors, I don't know what the actual life expectancy of these doors is, but it wouldn't surprise me if it was 20, 30 years. I don't know. We walk into supermarkets all the time. I don't think they have new doors. 20, 15 years after the doors are purchased, someone slips and somehow says it had something to do with the door at your supermarket. It shuts too soon on their cart or their body or whatever, something. They don't even know Stanley exists. They don't know who made the doors, who installed them, anything. They sue Shaw's. And they say, you were negligent. They have to defend that.
Yes, Your Honor, pursuant to the contract.
Okay, so what does this clause in the contract about their breach do for them or us? Right? What they have to defend against, I had it in front of me a minute ago. I'll have to find it again. Hold on. 104, I think. No, I don't know where it is now. Yeah. So the language is, it's in the present tense, which you might also want to address. Hereby indemnifies, defends, and holds harmless. It doesn't say will defend. It says hereby defends, but all right. Only for things that arise out of or in connection with the supplier or any of its employees' breach of any covenants, warranties, or representations made herein. The plaintiff doesn't allege any breach of anything, but they don't say this door was made wrong or installed wrong, designed wrong, anything. They say Shaw's was negligent and I got hurt with their door. So is it up to you in your head to say, yeah, but we think it's Stanley, so they have to defend?
Well, in the first instance, it's the first point, the plaintiff alleged that the door was defective, was dangerous and defective, which would be covered by the purchase order.
Well, it depends how it got to be dangerous and defective. If you let people smash supermarket carts into it forever, but it was a beautifully designed and not defective door when new, maybe they'd be liable, maybe they wouldn't.
Right, but it would be covered, the allegation would be covered by the scope of the duty to defend. And at the time that this...
Wait, the plaintiff is not saying it's defective because of anything Stanley did. They're saying it's all you, Shaw's. They filed a suit against Shaw's. So is it that you get to say it, or the scope is any allegation of negligence surrounding the doors in perpetuity is covered by this purchase order, and they're on the hook for hundreds of thousands of dollars of legal fees? They're not an insurance company. You're not paying them a premium every month. I mean, this would be a great insurance policy. I'm going to start putting this in all of my form letters that I send to people, and I can be defended against everything, right? I mean, I'm trying to figure out what the scope is supposed to be.
Well, it is a risk transfer provision that two commercial entities negotiated, two experienced commercial entities negotiated. But at the time that this happened, Stanley had provided a 3-year warranty on the parts and the labor, and this occurred within that 3-year warranty. The plaintiff's incident occurred within that warranty, so the doors are under warranty at that point.
Okay.
So the purchase order for the doors included that they'd be installed in a workmanlike manner, that they would be free from defects, and the plaintiff here has alleged that the doors were defective. So that arises from Stanley's design, installation, and so forth of the doors. And as to the if I've addressed your question, I just want to address the
Well, I mean, you've now said maybe it's limited to the 3-year warranty period, and that's something, although I know that's not really your position. You've suggested maybe we don't need to reach the rest of it, but go ahead.
As to the scope, there's no limitation in the scope. It says any and all claims arising from the door. And that would trigger the plaintiff's allegation would trigger that. And then in the amended complaint, the
Not
plaintiff...
arising out of the door, arising out of a breach of the warranties.
Right, the breach of the warranties to put them in a good and workmanlike manner, that they'd be free from defects, and the plaintiff here has alleged that the doors were defective. And then in the amended complaint...
Your position depends on us extending the in for one, in for all principle to a non-insurance context. Would you agree with that?
I don't, Your Honor, because
Okay.
the only claim against Shaw's is a negligence claim. And that's what Shaw's is seeking, a defense, for Stanley to pay its defense
Oh,
costs.
there's a negligence claim against Stanley for a defect in the manufacture, design, installation of the doors, and then there's a separate negligence claim against Shaw's, which, you know, if you read the trial transcript, they're separate claims. So,
Yes.
I don't read Stanley to be disputing that the amended complaint gave rise to a duty to defend the claim as to Stanley. But for you to prevail, for you to establish a duty to defend on the other claim, we have to apply the in for one, in for all, don't we? I mean, that's what the judge did.
Well, under the contract, the duty runs to Shaw's. So Shaw's would be entitled to a defense from Stanley on that single negligence claim.
If we're, I mean, it's not a claim against Stanley, it's a claim against Shaw's.
Right, and
Right,
Shaw's...
so, okay, let me give you a
sorry.
hypothetical. Let's say that Shaw's, after Stanley installs the doors, they're perfect, alters the door somehow, it retrofits it, and someone's injured, and they bring a claim saying, A, the doors were installed negligently by Stanley, and B, this retrofitting that Shaw's did was negligent. You're saying that Stanley has to defend against that second claim?
Well, the contract requires Stanley to defend Shaw's from claims arising from...
Stanley's breach of a warranty. So if Shaw's has altered the doors, how is that Stanley's breach of the warranty?
Well, there's no evidence here that Shaw's altered the doors, and I think
I'm
that-
asking a hypothetical. So in that hypothetical, would Stanley have to defend against that claim?
Defend Shaw's?
Yes.
Well, yes, because I think the plaintiff's allegation would cover, here the plaintiff alleged that Stanley, the claim against Stanley, that Stanley was negligent in
But
the...
that's because of in for one, in for all, which is what Justice Shin asked you initially. Is that why, even though the claim, look, you were found liable for negligence, presumably for adjusting the thingy that the motion detector wrong, right? Or I don't know what else you did.
it was
But
a
if
defense
the complaint had simply said, beautifully installed doors were put in the Shaw's supermarket, and Shaw's negligently repointed the sensor away from the proper area, and I was injured. Period. That's the claim. They defend you?
In that instance, perhaps the duty would have been different.
I'm asking if they have to defend you, not perhaps a duty. Do they have a duty to defend that action? You say that's not what happened at all.
Right.
And you bring a third-party complaint against them and say, we never touched that. It's because the floor mat was installed wrong, whatever. So you sue them. Do they have to defend you against that part of the claim for the moving of the sensor negligently?
I think under that limited circumstance, Your Honor, they may not have to, because the plaintiff hasn't generally alleged that the door was defective or that the door was dangerous. In this case, the plaintiff has generally alleged that the door was defective. Stanley's door was defective.
What if the claim was that you failed to have someone test the door from 3 different angles every morning, as you were supposed to? Would Stanley have to defend against that claim?
Well, broadly, I think that under the duty to defend and under the pleadings test, I think broadly Stanley would have a duty to defend that, because the plaintiff is making a claim that that door is defective. And I mean, the plaintiff also claimed...
No, I mean, one of the claims in this case was literally that you failed, Shaw's failed, to test the door every morning as you were required to, and that was negligent. Seems to be what the jury found, frankly. So does Stanley have to defend you against that claim? I know it's not the only claim you defended against, so I mean, there's other stuff in the case, but how about that claim?
Stanley does have a duty to defend that claim, because that claim is part of the plaintiff's negligence claim, and under the cases, under the pleadings test, that can't be parsed out. That's part of the negligence claim. I don't think it's practical that the duty to defend could be piecemeal and broken up.
I'm really having a hard time understanding why what you said is different than the in for one, in for all rule. Maybe it isn't.
Perhaps I didn't understand the question correctly. I do think the in for one rule applies can apply in a commercial case like this. I just think that in terms of the judge's application of it, there's only one negligence claim against Stanley, and I think it encompasses that entire, against Shaw's, and I think it encompasses that entire negligence claim. I also infer from the judge's ruling that he looked at the purchase order directly, which has no limitation on the scope of Stanley's duty to defend. The purchase order itself doesn't limit that in any way. It doesn't say.
It does. It limits it to claims arising out of Stanley's breach of a warranty.
Yes, but it doesn't limit it as Stanley suggests, which is that Stanley has no duty to defend Shaw's against claims of its own negligence.
It doesn't say so either. And I mean, the in for one, in for all has only been applied in the insurance context. I mean, Stanley is not an insurer, right? And frankly, I think this case shows that the claims could be parsed out because Stanley, in fact, appeared in the case and defended against the claim against it, and Shaw's defended against the claims against it, and the claims are parsed out on the verdict form. So it seems like they could be parsed.
Yes, but Shaw's is seeking to recover its fees that it spent.
I understand, but you're
plaintiff's
saying,
claim.
the in for one, in for all rule is there because it's difficult to or impossible to parse the claims. And the way this case was tried, it seems like it was perfectly possible to do that, right?
Well, I think there's only one claim against Shaw's, so everything that Shaw's did in the case was defending against the plaintiff's claim.
That's right, and Stanley appeared and defended against the claim against it. So I'm not seeing why it makes sense to apply the in for one, in for all rule here, even assuming it could ever be applied outside the insurance context.
I'm not sure I understand your question, because we're only seeking to recover the fees that Shaw's incurred. So we're not seeking.
I understand, but in order for you to recover the fees for the work you did defending the claim against Shaw's, I don't see how you get there without saying the in for one, in for all rule applies.
Perhaps it does then.
Okay.
But
Is there any case that applies that rule outside the insurance context?
I think under Saibi, the general guidance, the principle that what's used in insurance cases can be used in commercial contracts, that would be guidance for the court to look at that in terms of applying that in for one rule. I think if the distinction is, if the court's thinking of a distinction between, and I don't know if it is, but what was related to, Shaw's related to the defense of the plaintiff's claims and then the pursuit of the claim against Stanley, I'm not sure.
Can Stanley settle the claims against you?
Excuse me?
Can they settle?
The fee claim?
No. Some family sues you for injury. You say they have to defend. They look at it. They say, this is a pretty good claim. Shaw's was negligent here. We're going to settle. Listen, Shaw's, we're settling. Can they do that?
They could, but they'd still have a contractual duty to defend if that was triggered by the plaintiff's allegations.
Well, but if they settle the case, there's nothing left to defend.
Well, they still have a duty to defend the claims against Shaw's if they were triggered by the
Well,
plaintiff's
then you guys
allegations.
could fight about indemnification. I'm saying, can they settle the claim against Shaw's? In Saibi, the contract gave a power to settle to the...
Oh, in this case, could Stanley have settled the plaintiff's entire claim?
Yes.
Sure,
Okay.
I think so. And that Shaw's would still be entitled to its...
To indemnification, then you guys would have some little thing where it turned out they were not liable, it was all you, and that'd be it. You'd have to pay whatever they had settled for.
But Shaw's would still be entitled to its defense costs because the duty to defend is triggered when the plaintiff's complaint is filed. in those allegations. So whatever Shaw's incurred as defense up until the time of that settlement, it would be entitled to recover, because the duty to defend is activated as soon as that complaint is filed.
Yeah, sure, please.
I have one more question, counsel. Let's say we agree with Stanley that you're limited to fees resulting from the defense of the claim against Stanley. Do you have any damages? What's the disposition? Would it be a remand, or would it be just a reversal?
No, I think we did break that. We did break that down for the trial court, and as Justice Ditkoff said, I think it was around 3/4 and 1/4,
So it would be
maybe a little bit more on the 3/4, but
Well, I thought those fees were for establishing the duty to defend. Let's say we conclude that you're only entitled to the fees for defending against the negligence claim against Stanley. Do you have any damages, given that Stanley appeared in the case and defended?
yes, all of our fees were incurred in defending the claims that the plaintiff made against Shaw's and Stanley.
Was there a portion of them? Did anything you said and anything you filed to defend the claim saying Stanley was not negligent, or they covered all of that? Did you say Stanley was not negligent? Or did you say Stanley was negligent? If anyone was injured, it's not us, it's Stanley. I assume you
Did
said
say that. That was part of our defense.
Of course. All right, very good. It's a complicated and interesting case. Thank you both for excellent arguments. The case is submitted. The next matter we will hear is number 22-49, Amaral versus City of Fall River.